hopefully, we've got Alison, is it? And I
Yes,
also thought, right, cool. Thank you very much, Alison. We've got 10 minutes with you.
thank you. Kia ora. I'm Alison Pavlovich from the Outdoors and Freedom Party, and of course, one of the objectives of the party is to advocate for the protection of fundamental rights and freedoms for all New Zealanders. And so this bill has raised some interest and subsequently concern from members of the party. Um, so there's obviously two powers that are being introduced by this bill. Right at the beginning of the bill, the general policy statement says the bill reaffirms the New Zealand Police's long-standing ability to record images and sounds in public places and to collect personal information for lawful purposes, including intelligence. Um, I think, as you've probably heard already from many submitters, it's not really a reaffirmation because the law is quite clearly stated in Tamifuna, and a lot of those principles are supported by the IPCA and Privacy Commissioner report around taking photos in particular. And then it continues, the general policy statement at the beginning continues. It's okay, I'm not going to read the whole thing. It's just important, this little bit.
Yeah, no, that's right. We've got it here. We've all read your submission. We've probably got it on our screens right now, reading it with you.
Yeah, exactly, right at the beginning. The ability to collect and use information is essential to the police's delivery of a broad range of policing functions and services that support the vision for New Zealand to be the safest country where people can go about their daily life without fear of harm or victimisation. And it's really those last reasons that I think are the main reasons why the party do not support the bill, because of the fear of harm or victimisation. Okay, so just starting with the first power, the new power to allow police to record and take photos and other forms of taking images. So this explicitly runs counter to the finding in the Tamifuna decision. So I'm sure you're already aware the majority of the Supreme Court found that taking photos without the context of a specific investigation was an unreasonable search and breached the right that's granted to New Zealanders under Section 21 of the Bill of Rights Act. And I also want to note, and this was mentioned by Gihan Gunasakara, I think his name is.
Yes, that's right. Professor, yeah.
He talked about the fact that this is different, that taking photos is different. It's a next level to just taking a phone number and the name, because this is biometric data. And in the Tamifuna case, Justice Alan France specifically said that one of the reasons for the decision that the majority of the court made was this protection is a development as part of the response necessary to address the impact on Section 21 interests of increasingly sophisticated technology. So she's recognised that taking photos with increasingly sophisticated technology becomes more and more of a infringement on New Zealanders' rights. Of course, the IPCA Privacy Commissioner report also acknowledged that photographing members of the public was not acceptable without unless specific crimes were being investigated, and urged caution around those practices. And this bill is very broadly stated and really overrides that case, the Tamifuna case, and the concerns of the IPCA and the Privacy Commissioner. And certainly as a party, we are also concerned about the impact on the rights and freedoms of New Zealanders to go about their daily life free of threat or fear of being photographed or filmed by the policing wing of the New Zealand government. and having one's details held on file on a system without any reasonable justification. And this really is completely runs contrary to that initial paragraph in the general policy statement. It is because of the people wanting to go about their daily life without fear of harm or victimization that this first power shouldn't be introduced at all. I won't go over it again, but Tim Cochrane talked about the Section 7 report, and I have discussed it a little bit in the submission that we made. There are some weaknesses in that report, especially with respect to that first right. No proportionality testing has been undertaken. So I would urge the Select Committee to go back and look at that again, and because Section 5 of the Bill of Rights Act does require that where a specific piece of legislation is overriding a right in the Bill of Rights Act, there needs to be a justification for that overriding, and that needs to be done through a proportionality analysis. That's well established in New Zealand law now. Okay. I'd also like to acknowledge Elizabeth's submission to reiterate and say that I agree with the things that she said. She talked about speculative information gathering, and that's what this new right does. It definitely extends the powers significantly into what I would consider quite a dangerous territory. As long as I've got time, I'll just deal briefly.
I think we're just about there, so you better.
Okay, briefly with.
I see you've got one more thing about the traffic. Yeah.
Just with the respect to the second power, the power to close off areas. It's clearly written in the context in terms of the introduction around with a lens or its frame toward boy races or some sort of road traffic offences. But it could clearly be utilised a lot more broadly than that. And certainly our concern is the right to protest. So important. I wouldn't be sitting here having this conversation if it wasn't for protesters in the past, protesting for all sorts of rights that are now we regard as normal every single day. I think that if this is just a road policing issue, then that needs to be the legislation needs to be drafted more narrowly to ensure that's understood. At the moment, it could be used far more broadly than that. So it is also a concern to the party. I'll leave it at that.
All right.
Very much.
Thank you, Alison, for going through your 2 pages and very detailed. We're out of time, unfortunately, but